In the face of increasingly bleak warnings about the current state of climate change and the trajectories of climate change inducing emissions, and the frustration and slow progress in Australian climate policy, I wanted in this presentation to talk to you about something that might give you some cause for hope. And that's the really exciting new developments that we're seeing in efforts to use the courts to drive improvements in climate policy in Australia. We're seeing that litigation is becoming an increasingly important lever in climate policy for a range of reasons. Obviously, there's a hope that approvals of things like new coal mines will be reversed, or that approval conditions will be strengthened for activities that will increase CO2 emissions. Or there's a hope that the result of a court case will prompt governments to act to reduce emissions. But the way that our laws are currently framed often makes that unlikely. And so the benefits of climate litigation are seen in other ways. Litigation tests evidence. You have a court that hears evidence about how much CO2 can still be emitted in order to hold the world within 1.5 degrees of warming or 2 degrees of warming, the so-called carbon budgets, and the likely emissions from a particular activity. And then they give judicial endorsement to the weight of the climate science, which makes it much harder for that science to then be subsequently politicized or isolated or demonized. We will also see increasingly evidence of the impacts of climate change being led in court and accepted by courts, which will further underscore the legitimacy of the cost claims relating to the impacts of climate change. The trust that the general public in Australia places in our legal system and in the courts as compared to politicians means that judicial decisions can have a really powerful influence on social debate about the importance of climate action. It can maintain pressure on governments, and I'm going to show you an example of where that has been significantly ramped up in recent years. Sometimes that can actually backfire. Where you have a case that finds in favour of plaintiffs, or the applicants and governments consider that a case is just meddling in what the role of government should be, it can be painted in quite an adverse way as people waging lawfare on development activity. But for the most part, the fact that courts have lent their weight to a finding in favour of climate litigants can often increase the legitimacy of those claims. Australia actually has the second highest number of cases brought on climate-related grounds of any country in the world. The United States is way out in front, with literally hundreds and hundreds of cases active at the moment that are arguing a whole range of different climate-related issues in every single one of the individual states of the United States of America, as well as actions against the national government in the states. But one of the reasons why Australia has so many cases is because we do have such an incredibly poor track record of government-led climate change law and policy. We don't have an ambitious emissions reduction target, and the reduction target that we have is not enshrined in any kind of legislative target or framework. We don't have any formal laws that restrict new projects that will contribute to emissions, projects like new coal mines. And so there's very little in Australia in the way of laws that will actually force a shift towards a zero carbon by 2050 kind of target, or even to drive more ambitious emissions reduction goals. By far the majority of the court cases in Australia have focused on challenging both state and national government approvals of new coal mines. Some have also related to coal seam gas and natural gas development, but most of it has related to new coal mines. It's fair to say that Australia loves to mine coal to feed our aging coal-fired power stations, or most recently, the increasingly important role of coal for export. And we still have really vast untapped coal reserves in Queensland's Galilee Basin, and to a lesser extent in the Hunter Valley and the Liverpool Plains of New South Wales. So there's about 7 mega coal mines still on the drawing board, slated to open up the whole of the Galilee Basin to coal mining, predominantly for export. And yet, when Australia is setting our Paris Agreement targets, we're not required under international law to consider the additional emissions that will be caused overseas as a result of purchases of our coal, burning our coal. So these are referred to as Scope 3 emissions. They're indirect emissions because we're not actually burning the coal ourselves. The person or the country that we're selling our coal to is responsible for those emissions. So in terms of global greenhouse gas accounting, that's not our problem. We just dig it out of the ground and sell it. That's the responsibility of the person who decides to, or the country that decides to burn our coal. So the Australian government keeps on approving new coal mines, whilst also saying that we are committed to the goals of the Paris Agreement. Even though we know that to meet the Paris Agreement target of staying well below 2 degrees of warming, 90% of Australia's coal reserves need to stay in the ground. And while we may not need, as a matter of international carbon accounting, to factor in these so-called Scope 3 emissions into our own international targets, we know that as a matter of science and as a matter of just common sense, we can't afford to keep on mining coal and selling it for other people to burn. And that's why there has been so much litigation in Australia trying to prevent new coal mines. For well over a decade now, environment groups have brought actions challenging the approval of coal mines in Queensland and in New South Wales under both state and Commonwealth environmental laws. And I think it's useful to think about these in terms of sort of waves or generations of litigation. The first generation of climate cases used fairly traditional avenues like the grounds of review that are set out in environmental legislation, and particularly the Commonwealth's primary piece of environmental legislation, the Environment Protection and Biodiversity Conservation Act. So the EPBC Act requires the proponents of activities that are likely to have a significant environmental impact to obtain an approval from the Commonwealth Environment Minister in circumstances where that environmental impact is likely to affect a so-called matter of national environmental significance. And the Act actually lists what those matters of national environmental significance are. They include endangered species, World Heritage Places, the Great Barrier Reef, a range of other things. Climate change is not listed as a matter of national environmental significance. So the fact that an activity is likely to have a significant impact on the global climate doesn't trigger these approval requirements under the legislation. And that's made it really hard for climate cases to be brought under the EPBC Act. The matters of national environmental significance that have been relied upon are principally ones relating to threatened species, and in particular, the Great Barrier Reef, because we know that it's one of the most sensitive ecosystems that's already showing very significant impacts as a result of the warming that we've already experienced. So the only way that you can challenge a project under the EPBC Act's approval requirements is by arguing that the mine is going to lead to coal being burnt and that the resulting climate change will significantly affect a matter of national environmental significance, whether that's a threatened species or the Great Barrier Reef or one of the other matters of national environmental significance. Australian courts, when they are reviewing the Environment Minister's approval of new coal mines, have given the Environment Minister very wide discretion to decide as they see fit how we should consider the impacts of climate change on the Great Barrier Reef. So in these circumstances, the first generation of climate cases has focused on these approval processes. What did the Environment Minister consider when approving the new coal mine? Did they fail to consider the impact that burning this coal would have on climate change, and then the impacts that climate change would have on the Great Barrier Reef? And one of the difficulties that we've had with this first generation of litigation is that it's had to fit within these narrow categories of review that are allowed for under the EPBC Act. They've involved almost entirely at the Commonwealth level a process that's known as judicial review. Judicial review simply means review of an administrative decision by a court. In this case, the administrative decision is the decision of the Environment Minister to approve the mine. The constraint in seeking judicial review of administrative decisions in Australia is that the court can only examine the legality of the decision based on what the statute requires. So the court is not permitted to examine the merits of the case, whether it's a good idea to approve new coal mines. They can only look at whether or not the minister complied with the legal processes and took into account all of the things that the minister is required to consider when making the decision. So it's generally limited to looking at whether or not the minister failed to take into account all relevant considerations. And that's very different from a case that's based on what we refer to as merits review. So merits appeals are often heard by specialist tribunals. In New South Wales, it's the Land and Environment Court. In Tasmania, it's the Resource Management and Planning Appeals Tribunal. In Queensland, it's the Planning and Environment Court. They're specialist courts and tribunals with specific training. And with merits review, these tribunals actually put themselves in the shoes of the decision maker and say, was this the right decision to make on all of the evidence? Not could it have been made legally or lawfully, but is it actually a good idea to approve in these circumstances? And the EPBC Act doesn't allow merits review of the minister's determinations under the Act, at least in respect of these kinds of decisions. It's got a small area of merits review, but not for the purposes of this talk. So from the earliest cases, with the possible exception of New South Wales, the courts have been really reluctant to engage with the science of climate change or to conclude that it deserves more weight than the minister has given it. Particularly, there's been a very strong reluctance on the part of the courts to seriously consider what the Environment Minister's obligation is to consider these Scope 3 emissions, the emissions that are caused by burning Australian coal in China or in India. And the best example of that we have is a case in the federal court that was determining the legality of the Commonwealth Environment Minister's approval of the Adani Carmichael coal mine, which I'm sure many of you are familiar with. In that case, the Australian Conservation Foundation, a national environmental group, challenged the minister's approval of the Adani Carmichael coal mine on the basis that the burning of the coal from the mine would have a significant impact on climate change, which would in turn damage the Great Barrier Reef, which was a matter of national environmental significance under the EPBC Act. So in approving the mine, the minister had considered all of the information before them and had found that the emissions from the mine would be 4.7 billion tonnes of CO2 equivalent per annum. The federal court held that the minister was still entitled to approve the mine because the way in which those emissions would actually affect global climate change depended upon a whole range of variables. Even though we knew what the emissions from burning this coal would be, when you think about what its impact on global climate change might be, that depended upon whether or not Australian coal was going to be used as a substitute for some other polluting energy source. Maybe Australian coal is cleaner than the coal that was going to be used anyway. How efficient the coal-fired power stations were that were going to be burning the coal in China or India, whether they had good pollution control technology associated with those coal-fired power stations, and whether or not China or India are taking other steps to meet their obligations under the United Nations Framework Convention on Climate Change or the Paris Agreement. And on that basis, because there were a whole range of things that were beyond the scope of what Australia could take into account, the federal court said it was legitimate for Australia to approve this coal mine, the minister to approve these coal mines, because it couldn't be sure what the impacts of climate change were. There were so many variables, it wasn't possible to draw robust conclusions about what contribution this project would make. It was too difficult to identify the relationship between approving the mine and impacts on the Great Barrier Reef. And the court placed particular emphasis on the fact that emissions are intended to be managed through the Paris Agreement and these other international frameworks. It's a really frustratingly regrettable decision. It highlights how wide the minister's discretion is to ignore the reality that burning any new coal is surely going to increase the chances of contributing to climate change. And it highlights how narrow the court sees its role in evaluating the legality of the minister's decision under the EPBC Act. And I'm going to come back to the significance of that in just a moment. But I do want to contrast this interpretation under the federal EPBC Act with the New South Wales Land and Environment Court's merits review decision in a case called Gloucester Resources Limited and the Minister for Planning, also referred to colloquially as the Rocky Hill coal mine case. It's worth pointing out at the outset that this was not a challenge to a decision of the government to approve a mine. In fact, it was a decision by the Minister for Planning to refuse Gloucester Resources coal mine, and Gloucester Resources were seeking a merits review of the Minister for Planning's decision in the New South Wales Land and Environment Court. The appeal was joined by a public interest group supporting the Minister for Planning's decision. And that environment group brought evidence, including from Australia's leading climate scientist, Professor Will Steffen, that for Australia to meet its international obligations under the Paris Agreement, the coal reserves at Rocky Hill simply must not be developed. They led evidence to the effect, and this was a quote from Will Steffen in the Land and Environment Court, if you're really serious about Paris Agreement targets, we can't have fossil fuel developments. You cannot reduce emissions by increasing them. And ultimately, Chief Justice Preston upheld the Minister for Planning's refusal of this new coal mine. He held that every single thing that we contribute to the climate problem will count, and that the solution needs to happen at the level of every individual project. He held that we need to recognise the cumulative effect of every individual decision so that we don't end up with death by 1,000 cuts. This doesn't really make a big difference. This doesn't really make a big difference. This doesn't really make a big difference. But when you add them all together, they all make a difference. So Chief Justice Preston rejected the argument that, well, if we're not going to sell the mine, somebody else will, the coal, somebody else will. That's the so-called market substitution argument. And he took the view that an environmental impact doesn't become acceptable just because a hypothetical and uncertain alternative development causes the same unacceptable environmental impact. The ultimate conclusion was that a new open-cut coal mine would be in the wrong place at the wrong time. He found that it was in the wrong place for traditional planning reasons. It was a scenic and cultural landscape. It was close to people's homes and farms, and it was going to have really significant amenity and social impacts. What's interesting for our purposes is what he says about it being the wrong time. Chief Justice Preston says that a new open-cut coal mine is the wrong time to allow one because the greenhouse gas emissions will increase global total concentrations of greenhouse gases at a time when we urgently need rapid and deep decreases in greenhouse gas emissions. Now, we don't know yet whether other courts will endorse that wrong place, wrong time approach. And it really would be very welcome if we could see the federal court taking this kind of common sense approach to the interpretation of the impact of Scope 3 emissions on climate impacts and ultimately on the Great Barrier Reef. But at the moment, in that first generation of litigation, we have some very frustratingly narrow interpretations. And that's why I want to talk to you now about an exciting new phase of quite innovative legal actions that's on our doorstep. Overseas, it's targeted the climate policies of governments and corporations. But in Australia, what we're seeing is litigants moving away from these traditional judicial review avenues and pursuing claims in negligence and pursuing claims in human rights in particular. And those are the two that I'd like to just talk to you briefly about now. Interest started in the possibility of using negligence as a cause of action with a decision of the Dutch District Court in 2005 that was brought by an environment group in the Netherlands called Urgenda. The organisation represented a group of citizens who took their own government to court, arguing that the Netherlands' emissions reduction targets were inadequate based on Dutch obligations under the Paris Agreement. So Urgenda argued that the government was breaching the standard of care laid down in the Dutch Civil Code. We don't have a civil code relating to negligence in Australia. This is a civil law country, not a common law country like Australia. But the unwritten standard of care in the Dutch Civil Code gives judges broad discretion to interpret unwritten rules, much like our common law, and consider links to human rights and the effect climate change has on the right to a healthy environment. So the question here was whether the government owed its citizens a duty of care, in this case, to pursue more ambitious greenhouse gas emission reduction targets. The court held that the Netherlands 2020 reduction target was inadequate and therefore it was not fulfilling its duty of care to its citizens. And the court ordered the government to further reduce emissions by 2020 by at least 25%. The decision of the Hague District Court was upheld on appeal based on the Netherlands having a positive duty of care under the Convention for the Protection of Human Rights and Fundamental Freedoms. And the decision has been upheld by the Dutch highest court, the Dutch Supreme Court. And this Urgenda case has inspired some really interesting new litigation in Australia that many of you would already have read something about, presumably heard something about in the news. It's still aimed at preventing new coal mines. It's not aimed at changing government emissions reduction targets as such, but it is trying to prevent new coal mines, not using the traditional grounds in the EPBC Act, by introducing these novel causes of action, focusing on human rights and the tort of negligence. So what we have had recently is, I think, what we could fairly be described as a landmark judgment in the Federal Court of Australia in a case brought by this young student, Anjali Sharma, and against the Minister for Environment. In that case, Justice Bromberg of the Federal Court found that the Minister for Environment owes a duty of care at common law to avoid causing injury to young people while exercising her powers under the EPBC Act in approving the extension of Whitehaven Coal's Vickery coal mine near Gunnedah in New South Wales. So the Sharma case was brought by 8 Australian children, led by 16-year-old Anjali Sharma. She's 17 now. I think she turned 17 about the week that the decision was handed down. And they were represented in this action because they were minors. They were represented by a function referred to as a litigation guardian. And it was this wonderful woman, 86-year-old nun, Sister Marie Bridget. The children were seeking an injunction to stop the Federal Environment Minister from approving the extension to the Vickery mine, which would increase total emissions from the mine to 366 million tonnes. Interestingly, in this case, both the federal government's legal team and the court accepted figures on the financial costs of climate change to young people over their lifetimes. So the evidence that was led by the plaintiffs in this case was not challenged by the Commonwealth. So an expert witness estimated these losses as being between 125,000 Australian dollars and 245,000 Australian dollars per person. And this estimate was based on the IPCC's high-end emissions scenario, because that's the only one that's consistent with increasing coal production, which is what this coal mine approval would do. The expert witness drew on atmospheric modelling to provide projections for Australia on climate effects such as changes in temperature and rainfall. And then he quantified the financial and health costs of those changes across 3 timescales or epochs that would affect the futures of young people today. The first of those epochs is the period between now and 2030, and identified in that was impacts on housing markets, impacts of bushfires on housing stock, flooding, and so on. Epoch 2 related to the period between 2040 and 2060, and it focused on reduced earnings and ability to work resulting from business continuity impacts from extreme events. And then in Epoch 3, between 2070 and 2100, the focus there was on risks to health, because the young people of today will then be elderly, and the estimate was that 1 in 5 young people will be hospitalised during Epoch 3 due to heat stress in their older years. And Justice Bromberg found that in addition to the obligations that the minister has under the Environment Protection and Biodiversity Act itself, so the statutory criteria and the statutory things that the minister is required to consider, the minister owes a separate common law duty to take reasonable care not to cause climate harm to children when deciding whether to approve an activity under the EPBC Act. So the court found that on the evidence provided, climate change posed a real risk of death and personal injury to Australian children, and that 100 megatons of greenhouse gas emissions from the Vickery coal mine would increase that risk of harm. Any increase was important. And I know that there's a lot of text on this slide, but I really think it's worth reflecting on some key passages from Justice Bromberg's judgment. He held, it's difficult to characterize in a single phrase the devastation that the plausible evidence presented in this proceeding forecasts for the children. As Australian adults know their country, Australia will be lost and the world we know it gone as well. The physical environment will be harsher, far more extreme, and devastatingly brutal when angry. As for the human experience, quality of life, opportunities to partake in nature's treasures, the capacity to grow and prosper, all will be greatly diminished. Lives will be cut short, trauma will be far more common, and good health harder to hold and maintain. None of this will be the fault of nature itself. It will largely be inflicted by the inaction of this generation of adults in what might fairly be described as the greatest intergenerational injustice ever inflicted by one generation of humans upon the next. It's intensely moving and I think an incredibly powerful judgment. I say Justice Mordecai Bromberg is an absolute legend to have handed down such a brave and powerful judgment. And even though he declined to actually grant the injunction preventing the minister from approving this mine, he did grant a declaration stipulating that the minister owed this duty of care to avoid increasing climate harms to children. So the minister has to exercise that duty of care. Now, the minister is appealing this decision, I'm sorry to say, and I think that in a strict legal sense that this appeal may be successful. And I'd invite any of you to ask in the Q&A some questions about why I think that the appeal may be successful, but I won't go into that in this recording. But I do want to say to you that even if this case is overturned on a technical legal argument, the evidence that was accepted in this case by both parties is now on the public record forever. And this incredibly powerful statement by a justice of the Federal Court of Australia that is absolutely condemnatory of the government's position in approving new coal mines will remain on the books, even if it's overturned on legal grounds in the future. So I think this is a tremendously exciting and an incredibly important decision. And I think it's one that you should be excited about and incredibly hopeful about, regardless of the outcome on appeal. And I want to tell you a little bit about one final case. It's a significant case based in Queensland involving child litigants. It doesn't involve a negligence claim. It instead is the first test of Queensland's new Human Rights Act, which was enacted in 2019. The case is being brought by two groups: Youth Verdict, which is a group of 25 young Queenslanders aged between 13 and 30 years old, and the Bimblebox Alliance, which is a community group that has been formed to protect the Bimblebox Nature Reserve. This action is being brought against Clive Palmer's proposal to establish a new coal mine in the Galilee Basin, just south of Adani's Carmichael coal mine, part of which would involve the complete obliteration of the Bimblebox Nature Reserve. So you can see on this map that where the China First Coal Project is and where that whole Galilee Basin is in Queensland. And Youth Verdict and Bimblebox Alliance have filed objections to Waratah Coal's application for a mining lease and the Environment Authority that's granted by the Queensland government. And the process in Queensland is such that the Queensland Land Court hears these objections and then makes a recommendation to the minister on whether or not the government should issue or reject the final environmental approval for this mine. It is worth pointing out that the Commonwealth has already granted its approval for this new coal mine under the EPBC Act. So having it blocked by the Queensland government is the last hurdle, if you like. The case is going to hear arguments about the principle of intergenerational equity, which is a fundamental principle of international environmental law, and the impacts that the mine will have in breaching the human right to life of young people, because their lives in the future will be at increased risk from bushfire, disease, flood, heat wave, cyclones, the whole gamut. So Youth Verdict includes young Aboriginal and Torres Strait Islander people as well, and they're objecting to the project on human rights grounds on the basis that for them, the future will make it more difficult for them to practice and develop their culture due to land being lost to sea level rise, hunting practices being compromised by biodiversity loss, for example, on the Great Barrier Reef. So the biodiversity loss, the extinction of native species, changes in annual weather patterns, affects not just the environment, but also the cultures that rely upon those elements of the natural environment, and that interference with those deprives them of the right to culture. It's a very interesting and innovative development, and it's only possible in jurisdictions that actually have a Human Rights Act. We don't have a Human Rights Act at the Commonwealth level yet, nor do we have one in Tasmania. Queensland's Human Rights Act came into effect in January 2020, and it provides that every person has the right to life and has the right not to be arbitrarily deprived of life. The United Nations Human Rights Committee has said that climate change is one of the most pressing and serious threats to the ability of present and future generations to enjoy that right to life. The UN High Commissioner for Human Rights has confirmed that governments have binding legal obligations in international human rights law to undertake emissions reduction of greenhouse gases. Now, this legislation is limited in when human rights arguments can be used. They can't give rise to a standalone claim. All you can do is bring human rights arguments to the fore to support an already existing argument. So here, the rights of objection under the environmental legislation in Queensland and the Mineral Resources Act in Queensland, those objections are being bolstered or augmented by these human rights claims as well. The Queensland Human Rights Act recognises that everyone has a right to enjoy their human rights without discrimination. And another argument that's being put forward in this case is that this right to be free from discrimination will be undermined because vulnerable people, including children, people in remote and rural communities, and people living in poverty, will suffer the most from climate change, so they will be discriminated against. So children are recognised in law as vulnerable people in need of special protection. They don't have the power to influence decisions on climate change in any kind of formal legal way, yet they will feel the impacts of it disproportionately. So that's another facet to the climate change human rights arguments that are being brought in this case. The case hasn't been determined yet, but it demonstrates, I think, the way in which these new weapons, these new legal weapons are being deployed in the fight against this climate emergency. And I want to reassure you that there is a range of other innovative proceedings on the horizon in Australia, activities brought by shareholders against corporations, forcing them to do a better job of their own climate disclosure and accountability practices, trying to use non-climate law and non-environmental law as new tools to drive better climate performance and accountability in Australia. And I do hope that in the face of regular heartbreaking news about climate disasters and the utterly baffling progress from our political leaders on improving Australia's climate policy and climate performance, I hope that these cases can give you some glimmer of hope about the potential for domestic law, national law, not international law, but national law, to be a really vital tool for combating this climate emergency.